Hi there, everyone. Welcome back. This is Kyle from the law offices of Lee and Associates. This time, I'm going to talk a bit about I-829 litigation. It's a very niche subsect of immigration law, and there's not too many firms that are practicing it now. Basically, if you're pursuing EB-5, the final step is to apply for your I-829. This has generally been a pretty straightforward process. If your project that you subscribed to was able to complete the basic holding your funds for 2 years and creating 10 US jobs, typically most people haven't had too much trouble at the I-829 stage. And post RIA, I guess you could say, there haven't even been that many people who have reached the I-829 stage. However, as of late, I believe since February of 2025, there's been a new kind of scrutiny from USCIS in two ways. One, when you get an I-829, it can often come with a notice to appear in immigration court. And two, they've started looking back at source of funds related issues at the I-829 stage. Why is USCIS doing this? Well, I mean, the United States has increased scrutiny across the board, but particularly they're looking back at things they didn't like currency exchange. Potentially, they're looking back at people who use regional center affiliated loans, things like that. And because of this increased scrutiny at the I-829, we're seeing more I-829 denials, and more than ever before, people are ending up in removal proceedings following their denial. So what do you do if you find yourself in this state? Well, you're gonna find some issues up front, which is there's not too many lawyers who are practicing this because it requires kind of a very unique dual specialty of removal proceedings experience and EB-5, two things which are very distinct and separate. I just randomly happen to have both those skill sets because I used to practice in immigration court quite a bit, and then I moved into EB-5. When I switched, I was told that my previous experience wouldn't matter, but here we are now. There's a few firms out there who practice. They're the ones that you have generally heard of. They're larger. Kurtzman is a big one. Yeah, aside from finding an attorney, the big issue with that is immigration court. While it's federal law, you're going to have to report to the immigration court that is closest to you. So it might be tricky if you're in a state to find someone who can practice this and is willing to fly out to potentially represent you for in-person hearings. This dual specialty can also probably run up on the price tag because you need someone who knows EB-5 and removal proceedings. But at any rate, first thing you're going to want to do if you do get a denial is to take care of getting your ADIT stamp. You can just Google what that is. Then you're going to have to definitely retain a lawyer as soon as possible. You'll have to appear in immigration court at the date specified on your notice to appear. However, be advised that these dates can change. You can be issued a scheduling order. Your hearing can be pushed back. It can be moved forward. It's all pretty annoying and inconsistent and difficult to deal with, which is why I always recommend hire an attorney right away who can sign in to their EOIR account and can enter their appearance for you on your case so that you don't miss anything. Probably the biggest hurdle in immigration court, and I think something that they do on purpose to be a little cheeky and to remove more people, is that they send out orders and requests and change deadlines and timelines, expecting that, yeah, people move, and then if they don't see this or if the mail's lost, then they can just issue a removal order and not have to actually pursue the litigation. So at any rate, very important to do that. The first thing you're going to have to do is a master calendar hearing. You and your attorney will show up, hopefully virtually, but potentially in person. And you're basically going to get scheduled for your individual hearing. But this is also a good opportunity for your lawyer to argue your case and to try and scare the immigration judge into just approving your I-829 or freezing your case or putting it off until later. So the advantage with ending up in immigration court after you already have the conditional green card is that you actually get to hold on to that status. I mean, I would say traveling, things like that, could put you at risk, because if you are traveling internationally and the customs agent sees that you have a notice to appear, then that could be an issue, even though you might have the ADIT stamp or you still have your conditional green card. I mean, I've heard of such a case where actually I think one of the few cases that has been fully litigated was someone who was exactly that scenario, where they were traveling, they were detained, put into expedited removal, and so they had their master hearing and their individual hearing, and they actually won in immigration court, and I'll get a little bit more into that later. But yeah, so generally you want to be a little bit careful, even though they're technically not supposed to detain you. Everything is kind of running a little bit crazy, as you may know if you've been following the news. Right. But master hearing, your lawyer does have an opportunity to show up to the court and tell the judge, hey, this person, my client, has been denied unfairly based on source of funds. USCIS never officially made this rule. They just changed their adjudication standard. I'm citing this federal case, I'm citing that federal case that said this kind of source of funds was okay, and here's 2,000 pages of financial records and EB-5 filings. Take a look at it, which apparently is a strategy a lot of firms are going for who practice, is just to overwhelm the DHS attorney and the immigration judge. I mean, the state of immigration court right now is pretty poor. DHS attorneys, I'm told, are straight out of law school. They don't really know what they're doing, and they're really just arguing asylum claims all day. And immigration judges, a lot of the good ones that I used to appear in front of have been fired because they were following the law and approving asylum cases and cancellation of removal cases here and there, and the current administration doesn't like that. They just want blanket deportations. So a lot of the new immigration judges are from the military, or they're relatively new. I even saw an email circulating that was like, become a deportation judge today. Anyway, it's all very silly and difficult, and I'm sorry for anyone who's currently going through this situation. But yeah, there has been some success at the master hearing arguing just to grant the I-829 there. Again, most judges don't know anything about EB-5. DHS certainly doesn't know anything about EB-5. In theory, I've heard that they're hiring EB-5 experts to consult on the side of DHS for individual hearings, but I mean, I've just heard this. I can't imagine there's many EB-5 attorneys who feel like doing that. I don't really expect they'd be getting paid much. So hypothetically, let's say you do your master hearing, you're going to be scheduled for an individual hearing, possibly within a few months, but more than likely a few years, hopefully at a time where the administration is different. But during that time, you'll still maintain your conditional green card, but you will also be in removal proceedings. You won't be uncrewing unlawful presence, so you don't really have to worry about that. I'd say if you're arguing something source of funds related, you're in probably a better spot. If your I-829 denial is from project failure, that might be a little more difficult to prove that you should be approved for the I-829. the immigration judge has the final say, which is kind of silly because they don't know about EB-5 for the most part. You really have to consider for every one I-829 EB-5 case, they're seeing thousands of asylum cases, and they don't really know what to do. And certainly, if you show up and you give them 2,000 pages of financial records, they know they're going to be in court for days litigating this, and your attorney can bring all kinds of witnesses and really drag this thing out, which is just going to cost them a lot of time. I mean, in the time they could to figure out your case and to litigate it, they're going to have to probably spend as much time as it would to process 10 or more asylum claims. So it's not a very hot prospect for them, especially I think a lot of these immigration judges, based on what they see, I mean, of course, under this administration, they're inclined to deny as much as possible, but relatively, when they see someone who's invested $500,000 or $800,000 into a project, the project was successful, they did all the steps they were supposed to do, and they simply are getting caught on some USCIS internal rule change that they never published, I think the odds are there that they're going to feel a bit more sympathy compared to their other clients. Is there anything else to add? If you are denied by the judge and ordered removed, you can appeal to the BIA, and once you appeal to there, I think it's like a $1,000 fee payment, and you basically send a brief. You can even request argument in front of the appeals judges, but I don't think many attorneys do that. I never used to do that, but strategies might change. And then they can take anywhere from, a few months or a couple of years, depending on if they lose your case. So during that time, you would still hold on to your conditional green card, to my knowledge. And then if you are denied at the BIA, that's when you can finally go to federal court. So you appeal to a circuit court, and then you can end up in front of a federal judge. At that point, I mean, I don't take on federal litigation cases, so it would be out of my hands, and it would be kind of new territory, but I think your odds might be decently okay. I mean, if you're at that stage, you should definitely retain an expert and discuss with them. Some people are saying, okay, well, my I-829 was denied. I want to bring this to my federal district court because I think I have a good case. I can cite matter of Zhang or something. That's fine, but if you have a dual federal court case and an immigration court removal proceedings, you're going to get basically a motion to dismiss at the federal court saying, hey, immigration court is handling this. This is a duplicative matter. Please dismiss. And from what I've heard, the federal court judges are very quick to get rid of those cases. So just to save you some money down the road, be aware of that. Not too much else. I mean, this is a pretty niche area of law. There's only a few firms handling these cases. I expect in the next 6 months there's only going to be more and more people in this position, but I still think at the rate immigration judges are being turned over and how busy they are, I still don't think they're going to develop that great of an understanding of EB-5. It's going to remain kind of a novelty, but generally you should try and retain someone with this dual area of expertise just to be safe. I mean, I've worked with many removal attorneys and they're sharp, but this is something that's a bit outside the norm, so you might want someone who can articulate EB-5, or maybe if you already have your EB-5 attorney, you can ask them to help and be an expert witness potentially with your removal attorney. It's possible as well. But yeah, I'm just gonna call the video now. If you have questions or you want a consultation, my website link is below. You can also check out the subreddit. I've written about this a few times. Maybe it's a little annoying to get to, but I'm always happy to take consultations and help people out. And yeah, Take it easy. Bye-bye.